legal analyst still with us from Nashville, Tennessee, criminal defense attorney Cynthia Sherwood. And thank you to Kirk Nurmi in Phoenix, Arizona, former criminal defense attorney who represented Jodi Arias. I always appreciate you joining us, Kirk. Let me start with you, Kirk, because two different styles, and I specifically want to talk about the last of that closing statement. It was rebuttal offered by the prosecutor, Ronald Dowdy, and boy, using those bullets versus the defense that was a little more laid back. How impactful was that to a jury, in your opinion?
Well, I think in many ways it was impactful, but I remember when I was watching this live, actually, I was thinking, why isn't the defense objecting? Because what was Mr. Dowdy's argument directed at, particularly that moment that you saw there where he's putting the bullets into the chamber? It was emotion. It was all emotion. And to me, that's objectionable. And also, of course, you know, when you take the bench, when you read the jury instructions, Judge Ashley, that you say jurors aren't supposed to make their decision based on emotion. And the state is really, in their closing argument, was really asking the jurors to form a basis for conviction entirely on emotion. They called no witnesses to address the issue. No one was disputing the tragedy of the situation. I'm certainly not doing that with my comments here. But ultimately, you have to wonder how effective that is when they're told not to consider emotion and look at the legal issue in front of them, and that is the insanity of Mr. Reinking.
And you know, that rebuttal started off with, we didn't wait an hour plus minutes to mention the victims like the defense did. And that, too, I think, plays on the emotion aspect of it that you're referring to. Cynthia, what are your thoughts about these closing arguments?
I do agree that it was all emotion-based, the majority emotion-based, the entire scene with the bullets, and a lot of the graphic testimony was emotion-based, especially and irrelevant in this sense. In this case, the defense is, yes, those things happened, but it was based on mental illness, that he could not appreciate the wrongfulness of his conduct based on his serious mental condition. So I do think I think it was, you know, great strategy for the prosecution if they could get away with it, and they did. But it was directly related to emotion, and it ties back into a lot of the testimony that came out in the trial and also in the opening, where you saw these victims humanized, and details irrelevant to the crime were brought in to bring in the emotion and humanize them, even though it does not bear on the defense in this case.
All right, Kirk, what would your strategy have been? And I'm really looking at the defense now because we know they had the burden to show the legal insanity by clear and convincing evidence. If you're there in front of this jury with your closing argument, what do you think you might have done to say, this is why you need to believe he did not? Because I think there's probably no argument that he was schizophrenic. I think that that's been pretty clearly established, but what about that second prong of, and at the time of the incident, he did not know right from wrong?
Well, you know, I would have begun, I probably would have done a lot what they did in just a little different manner, I guess, and that's a matter of personal style. But I would have gone in there and acknowledged the tragedy, acknowledged everything, but tried to focus the jury on the issue at hand, that they needed to decide whether or not Mr. Reinking was sane or insane at the time of the offense. And I would have tied back the testimony of the two experts and who opined exactly that. And then I would have said, I would have pointed out, and this would have been a major emphasis, a major theme of my closing, that the state offered nothing to contradict those opinions. They might have argued with them, they might have be bringing in emotion, but they did nothing to contradict those opinions. And I would have focused on that and hammered on that, because when they got that jury instruction saying they're not supposed to base on emotion, then the jury would turn to those assessments, those uncontradicted assessments, and hopefully with that find the client not guilty by reason of insanity.
And Cynthia, as I was watching this trial, I was fully expecting that the prosecution would have an expert, right, to contradict, to Kirk's point. Were you surprised, or what does it say to you that the prosecution, in fact, did not present an expert to contradict the defense's position?
Yes, you would expect that. Usually you expect to see the battle of the experts. In this case, the state psychologist agreed with the defense. And then additionally, Dr. Wood agreed with the defense as well. So you're left to believe that they could find no expert that would contradict these two psychologists. So I would have expected to see it. Now, I will say that it is not necessary under the law in Tennessee. We have one case where there were 5 experts that testified on behalf of the defense and 0 for the prosecution, and there was still a finding of guilt, a rejection of the insanity defense. But yes, I definitely think it hurts the prosecution, and I think if they could have had such an expert, we would have seen it.
Right.
And
I didn't mean to interrupt you, but also to your point that it's also strategy. And if they had an expert, I agree with you. I think we would have heard from that expert. Stay with us. Both of you are going to be with me as well, because we have several stories you won't want to miss. A plea change from the men convicted of killing Ahmaud Arbery. Was this a smart strategy? And the death of a black man who was shot during a no-knock warrant. We will show you the video.